Welcome to Cyber Survivor. This episode will explore the recent events of Oracle and their two associated breaches. I'm Dan Dodson, the host of Cyber Survivor, and with me today is Thomas Ritter. Welcome to the podcast.
Thanks, Dan. Excited to be on.
Yeah, really appreciate you coming on. It's been a lot of activities related to Oracle Health, and we'd love to explore the legal side of that. So before we jump in, give the audience an opportunity to learn a little bit more about you. So share your background with us if you would.
Sure. Yeah. So I'm a legal practitioner. I've been practicing law for just around 10 years, which is hard to believe. And the last probably 5 or 6 of those years has pretty much solely and exclusively been in the privacy and cybersecurity arena. So it's really all I do every day, all day. And it's a fascinating area of the law to practice and be in.
Yeah, no shortage of activity for you, Thomas, right now, unfortunately, right?
That's
There's a
right.
lot.
That's right.
There's a lot of activity. I want to start by exploring the situation surrounding Oracle right now. As the timing of this recording, there's been two potential breaches with Oracle. One surrounding Oracle Cloud, and the other surrounding some legacy servers that date back to their acquisition of Cerner, that was in the control of Oracle but had yet to move to their cloud. And I want to start, Thomas, with, the industry and market's a bit confused right now because, again, as of this recording, Oracle has not confirmed or denied either breach. And yet we know of clients and health systems that have been contacted by Oracle that there may have been an attack on some of their data. So why do you think an organization would privately start talking with clients and yet publicly either no comment or deny the fact that there might be a breach? Like legally, why would that strategy be one that somebody might use?
Well, quite simply, I think to me that tells you that they're trying to still get their arms around this thing, right? I know it's publicly been reported that they've retained CrowdStrike as their digital forensic and investigative response firm. But I would imagine that, they're burning the midnight oil and sifting through forensic artifacts to really try to boil down what sort of malicious activity took place. And it's really a microcosm of this current environment. And what I mean by that is, you have threat actors that have become rather adept at slowly leaking information related to an incident they either perpetrated themselves or, maybe a larger threat actor group did that they are involved with. And, in essence and in turn, it causes the victimized organization like Oracle to rush to respond accordingly, while you have independent security researchers out there that, are kind of vetting and validating that some bad things took place in real time. So a lot of competing interests. I think from a corporate perspective, Oracle's legal advice is probably to, as have these conversations offline, to put very little in writing. I myself have advised clients to take that approach at certain times over the course of my career. And that really stems from the fact, as I said, that, they're in the midst of just trying to figure out what exactly went on and to perform the forensic investigation.
So you think this more has to do with the organization being in the discovery phase of what actually took place versus trying to posture and not admit guilt, so to speak, from a legal perspective. It's more about they're still in the discovery phase, is what
I'd
I'm
like
hearing.
I'd like to think so, Dan. I mean, I know that there have been articles that seem to indicate there's a little bit of wordsmithing and wordplay going on, right, with respect to, you know, Oracle Cloud having previously been, referred to as a different name, right, and this activity taking place on servers that were under a name separate and apart from Oracle Cloud, and if that's the case, I would not endorse nor be legally advising that they try to get cute and play with distinctions over prior legal entity names, but rather just own up to the fact that they're investigating, they're trying to figure things out, they're looking into it. I mean, we we oftentimes tell clients, and it really speaks to the larger conversation around incident preparedness, which I know we're planning on getting into, but this is why, you know, simulating these sorts of things is so important. This is why having an internal and external communication strategy is so important. You know, having a prepared media holding statement is important so that, you know, you're not caught flat-footed when this sort of thing happens. And, you know, you have decision makers that have been in a room that kind of simulate and work through this sort of incident to where they can try to do their best to provide information, meaningful information in real time, while also simultaneously protecting corporate interests.
Yeah, it's a balancing act for sure. Because look, these organizations are wanting to take care of clients. I don't question that by any stretch of the imagination. But understanding the nuances of a successful attack on an organization while also trying to balance the interests of the organization is a difficult feat to have for sure. Um, I'll pivot just a little bit. There was a class action lawsuit filed in the state of Texas against Oracle Health. Some reporting has linked the sudden outreach to certain Oracle clients and used this class action lawsuit as a catalyst for more transparency surrounding these events. I don't know if that's true or not. It could very well just be a timing and investigation perspective. But focusing in on the class action lawsuit, do those work? Is that helpful? Is it just a bunch of fodder that goes away? Talk to us a little bit about those.
Yeah, I mean, gosh, it's really fascinating from a legal perspective, just the rise in data breach class actions. I mean, you that wasn't a thing 4 years ago. It really started to take off with the plaintiff's bar, and I would say early 2022. And then exponentially, it's just exploded to where I tell clients that if you have a security incident that rises to the level of a breach, and prompt some sort of legal notification obligations to, you know, a large population of individuals and or state federal regulators, you can pretty much almost guarantee today that you're going to get sued and be a defendant in a class action data breach lawsuit. So, you know, the plaintiff's bar has really gotten rather adept at jumping on these things fast. There are even, I've mentioned this and speaking with other folks and some other podcast plaintiffs firms out there that literally will scroll websites like OCR's Wall of Shame or state attorneys general websites where, you know, they'll publicize the fact that a breached organization has provided notice. And almost as soon as that happens, there's a flurry of litigious activity that then ensues and takes place. And then too, right? It's, I think, to answer your question about, you know, is there merit to this? It's hard to say. I mean, when they're just in the initial complaint phase of litigation. But what is interesting is you've seen courts become very receptive to these cases getting past the motion to dismiss or motion for summary judgment phase. And as a plaintiff's attorney, and full disclaimer, I'm not a litigator, but that's all you can hope for, right? You're hoping to get to discovery. And with a lot of these data breach class action lawsuits that have settled in recent years, it's because the plaintiffs have gotten to the discovery phase. And, you know, litigators will tell you, you reach the discovery phase, it's kind of all bets are off, right? Especially with respect to, you know, the hard hitting questions that then inevitably come about what did you know and when did you know it, and really the fine tune analyzation of breached organization security posture, right? You know, speaking to healthcare, it's, well, we want to see the last few years of your risk assessment, and we want to know, you know, when you may have identified certain vulnerabilities like this CVE that's at the heart of the Oracle Cloud issue. And why wouldn't you have rectified that situation if you knew about it? So too early to say with respect to this particular class action lawsuit versus Oracle, but suffice to say, it won't be the last. And I would imagine it won't surprise me in the slightest if in the ensuing days and weeks they reach double digits. I mean, that's what happened, right, with both Change as well as Ascension.
Yep.
both of those organizations within, a matter of days, weeks, were the subject of double digit class action lawsuits after having gone public.
Yeah. Well, and how does that change the landscape from organizations not wanting to go public with this information? Right? I mean, link these 2 points of our discussion, right? I mean, there's already a class action lawsuit, yet again, to my knowledge, there has not been an admission of a breach by Oracle publicly. They've talked to some clients, as it's been reported, but like link those two conversations together for us, Thomas, right? Like it makes me less likely to go public with
Sure.
things until I know exactly what's going on, which leads to this transparency issue people are feeling right now.
Yeah, I think it's a really good point. I mean, just speaking with respect to how I treat these issues with clients, I mean, I think these days it's almost inevitable that if you have, let's say, a severe security incident like a ransomware, it's going to get out, right? And so the idea of recognizing that fact and responding appropriately is a better approach and tact than the whole we're going to try to sweep it under the rug and hope that no one finds out. And mind you, your legality and liability around the latter approach is going to significantly increase should, it later come to light that you knew things that, prompted you to legally notify the appropriate individuals, and you chose not to, right? I mean, that's just not an approach that regulators are going to view or take kindly to.
Yeah, I think it's less about sweeping it under the rug as it may be. I want to get my arms more fully around the situation before I publicly admit to something so that I can have a more full story to bring forward. Right. So maybe it's more of a, impact on the delay of in timing of, I'll say, admission for lack of a better term versus what you might see as is a faster moving. If this whole notion of these class action lawsuits plays into the calculus of when do you communicate? How much do I need to know
Sure.
before I communicate?
Well, and I think what you're speaking to is the nuance between having suffered a security incident and, right, having that incident rise to the legal definition of a breach. So you can thread the needle of those as a organization that's undergone a security incident like Oracle has, and I think publicly attest to the fact that we've had something go on, we're looking into it, and we are doing our best to provide real time updates, right? There's that approach does not infringe upon them still trying to determine legally what their obligations may be around if that incident rises to the level of a breach.
Yeah, that's a great point. That's a great point. Last question that I have for you as I think about legal ramifications of the Oracle situation. So there's been some reporting out there that the correspondence between Oracle and clients has centered around there was an event, a security event, and there may have been some records exposed that would require the covered entity to report, to the OCR and subsequently their patients that are affected. But it feels like current reporting is that burden has shifted from Oracle to the health system, and the health system must determine on its own, on a case by case basis, whether or not they need to report and they need to contact the affected individuals. Where does the liability sit? What's the right approach? Assuming this reporting is accurate, what are your thoughts on that?
Yeah, it's also another really good question. I mean, I some of that really boils down to what the contract reflects between the client and the provider. Who bears the brunt of, notification obligations and the costs associated with such a thing? We saw this play out a little bit with respect to change. Again, harkening back to mentioning change, there was a huge impetus and push behind all the various providers that were impacted by the change ransomware to have change bear the brunt of responsibility and notifying impacted individuals. And I mean, for the first time ever, even to the point of the Department of Health and Human Services and OCR publicly reflecting, right, that they expected change to work with impacted parties and providers to fulfill that obligation. So I think that's something that I always tell people, it's best if you stipulate in the contract, who's going to do what. If not, then more often than not, it flows back ultimately to the owner of the data, right? Not the provider. And in turn, it creates significant conflicts around you as the owner of the data, being at the beckoning call and awaiting, forensic investigatory results of the provider, all the while sweating whether or not you may not end up in compliance with, providing timely notice. So
Yeah.
it's a difficult situation to be in.
Yeah, very much so, especially as you think about the complexities around third party risk, right? The flow of data in healthcare to provide clinical care. It just becomes more and more complex every single day. Um, well, any other comments that you have relating the Oracle situation?
Yeah, no, I mean, I think I'm glad you mentioned third party risk, right? I mean, I feel like that's been the story, if you will, of the world of breaches for the last 6 to 12 months. I mean, you've had just high profile breach after high profile breach really emanate from, a third party provider. And it just exemplifies and speaks to the importance of having a TPRM, program in place, a framework, and ensuring that you're doing the best you can as an organization to understand the flow of your data, who is involved and in charge of how that data then flows, and the responsibilities around the functions and jobs of those providers therein.
Yeah, absolutely agree. And it will be interesting to see how the events surrounding the Oracle situation unfold over the next couple of weeks and months. Thank you so much for your perspective on this, Thomas. Really appreciate it.
Thanks,
And
Dan.
this is Dan Dodson with Cyber Survivor.